Good afternoon, everyone. This is Zach Lucas from McCarthy Denning. Obviously, today is India by the Client Virtual Round Table discussion. Happy to be joined by Shira Rao, partner ASB Partners. For some of you used to tuning into these things, you would have seen Shira in the Governance and Succession series, where she teamed up with the Indonesian counterpart. So Shira is back to help us through with on the India aspects. And we've also been joined by John Shoemaker and his colleague Ivan Ling, both from Butler Snow, and they'll be covering the US angle on this, the fact patterns that we run through on these virtual tables. We're also very happy to introduce Diana Hamid, managing partner of Diana Hamid Attorneys, and Diana's in Dubai, and she'll be helping us with the UAE aspects of the virtual round table. For today, India Private Client Virtual Round Table. Now, the agenda for today is, as with all of these virtual round tables, we go through a domestic case study where we look primarily at a domestic Indian resident domiciliary and look at the fact pattern where that individual has assets abroad. And then we have a few life cycle events occur, divorce, etc. So we'll look at from the compliance, matrimonial, divorce, and succession aspect, and then we'll pivot and do the reverse, which is the foreign case version of this, where we have a non-resident Indian outside, obviously, of India, but with assets in India and around the world. And here we'll look at the compliance, matrimonial, property, divorce, succession again, but in reverse, so that we can see how it would work, where we're dealing with an NRI instead. So, commencing with case study 1. So here are the fact patterns. As usual, we always start out with a hypothetical fact pattern for these particular case studies. So in this case, we have Akash, who's married to Sapna, and they have one child, Anika. Akash has a trading company in India, a depository account or an account, and is also domiciled, citizen domiciled in India. Akash also has a UAE trust, and for today's purposes, we obviously have different financial free zones in the UAE, but we'll concentrate for today's purposes just on the DIFC. So we'll assume that we have a DIFC trust which holds an account, and we have a company in the UAE. We also have an account in the US, as well as land in the US. And then lastly, from the UK perspective, we have an account and UK land. So these are fairly standard fact patterns. But the key aspect here is Akash is Indian citizen, resident, and domiciliary. Okay, so a totally domestic individual with a domestic family, so that the family are not internationally spread. So unusually on these virtual roundtables, we don't generally go into tax. But in this case, we're going to look at the tax compliance aspects as an additional feature. So from a tax compliance perspective, looking at it from an Indian standpoint, I think what we'll discuss is the following: the scope of domestic taxation, income gains, and particularly if there's any inheritance taxes. The basis of taxation in India, is it global territorial remittance? How does it work? And the attribution of taxation. And here we're really looking at things like a CFC-like rule for the UAE trust income and gains. Can that be attributed? Likewise, the attribution back to India for taxation on UK and US investment income. And then finally, and then I think this is going to be a theme of this particular PRT, is what can we expect from an Indian tax administration perspective in respect of the recovery from COVID-19 and how it may affect high net worth families. So I'd invite Shira to just take us through from the top, the scope of domestic taxation right through to basis and then the attribution and the COVID recovery.
Sure. Thanks, Zach. So on the first question regarding the scope of domestic taxation, India, like several other countries, taxes its residents on a worldwide basis, and it taxes its non-residents in relation to their Indian source income. We don't have worldwide taxation based on citizenship or domicile or any other factor. So it's primarily based on the physical stay and the number of days that a person would have spent in India, on the basis of which they're determined to be resident and then taxed on a worldwide basis. A similar rule applies for capital gains as well. we don't have an inheritance tax in place at this point in time, but it is likely that if and when it is introduced, that we would follow a similar scheme to what we do in our income tax laws as well. Although that's of course hypothesizing at some level. The basis of taxation for Indian source income can be, it can trigger on a number of situations. So remittance could be one of the situations in which it triggers, but it could also be if the income accrues or arises in India or is deemed to accrue or arise in India based on certain factors. So, for example, for capital gains, if an asset is situated in India, then it would typically be considered to be sourced in India, irrespective of the location of the asset holder. And so you would need to look at the source rules as are applicable for individual assets or individual sources of income. The next two questions are actually a similar question. So, on the attributed tax of UAE trust income or attributed tax of UK US investments, what we need to keep in mind is that India does not have CFC rules in place as of this point in time. So, what you would be looking at is whether this offshore company, if it's a company, can be considered to have its place of effective management in India. And the way in which India determines this is similar to how it would be determined under the OECD treaties, although there are a couple of points of departure. And for trust income, we don't have a specific residency rule that tells us how offshore trusts would be considered resident in India or how their income would be attributed to India. So there are a couple of possibilities that could apply. One is if an offshore trust has even a single trustee in India. So, say there's a board of trustees with a majority of them being non Indian resident, but with one Indian trustee, then one of the provisions in our residency rule says that if even a fraction of the control and management of this offshore entity is in India, then it could be considered to be resident in India and therefore taxable in India on a worldwide basis. Now, this provision isn't applied specifically to trusts, but it does apply to non-corporate, non-company entities. So this is the rule that applies to partnerships, for instance, and therefore there is a possibility that it would be extended to trusts as well, since trusts are not considered to have legal personality in India. So short point being, trustee in India could be a potential situation where an offshore trust is taxable here. Another possibility is if all of the beneficiaries of an offshore trust are resident in India, and this is if it's a discretionary trust, or if it's a specific trust with some beneficiaries resident in India, then what would effectively happen is that the trustee who is considered a representative assessee of these beneficiaries could be considered taxable in India because of the residency of the beneficiaries in India. And that's something that would need to be examined depending on the details of the trust structure, whether the beneficiaries can be considered to have fructified claims in the underlying distributions and so on. Other than these two broad rules, we don't really have too many rules for notional attribution of income. Although you would need to keep an eye out for it because CFC rules were in contemplation a few years back, and I wouldn't be too surprised if they're introduced at some point in the future. Um, on the last question, Zach, post
Mhm.
COVID-19 tax administration responses, we have had some relief introduced for in relation to individual residency. So we had some communications put out last year that if individuals were stuck in India due to travel restrictions, and we had pretty prolonged quarantine periods after COVID started. So, what this communication says is that if they were unable to leave India during those specific periods, then those periods would not be counted in relation to the determination of their individual residency. What the communication does not do is provide a similar relief in relation to permanent establishment exposure. So, in a lot of our treaties with other countries, for instance, you would have number of day requirements in relation to when a PE comes into existence. So, for example, it could be a 90-day requirement if it's a service PE, for instance. And there's been no relief that's been provided on that front, which could potentially create permanent establishment exposure for some kinds of offshore entities.
Right. In terms of the post-COVID response, Do you anticipate, or have there been any sort of soundings that the Indian Revenue Authority will become a little bit more aggressive on avoidance behavior and sort of tax planning that they feel is aggressive? Or have they, have we got any indication of a timeline for inheritance taxes or potentially a CFC introduction? How are you seeing that shaping up?
So CFC is an issue on which there's not a lot of conversation today, to be honest, although we did have draft regulations put out a few years back. Inheritance tax, on the other hand, is discussed every year, every time the budget comes out. Although the word on the street is that with the economy as it is right now, and the period of slowdown as it is, it's unlikely that the government will introduce an inheritance tax at this point in time. Although the financial incentive for it exists because it would obviously contribute to revenue at some level during the period of slowdown, I think they're also conscious of the fact that it would have an impact on sentiment, which they don't want at this point in time.
Right.
So I would be surprised if they introduce it this year, although it's definitely something that's been on their mind.
Right.
On the issue of avoidance, I would not think so. I mean, although this is not the kind of thing that they tend to put out in public domain. Like I said, there is a general sort of concern around the sentiment and the economic slowdown. So I think that would reflect in terms of the attitude of the tax authorities as well.
Right.
Hopefully.
Okay. All right. Thanks very much, Fiona. So what we'll move on to is we'll look at the tax compliance aspects in the UAE. And there's a couple of questions that I'll ask here. The scope of taxation for foreign ownership, and in the UAE in this case we've got Akash owns a company and he's also settled a trust in the DIFC, and the trust holds an account. So we're looking at the basis of taxation for those entities where there's a foreign element, and then the exchange of information under the CRS, and that's looking at the whether or not there's a live bilateral agreement under the CRS between the UAE and India where information can flow. And in this case, probably the candidate is going to be the underlying account of the trust or the trust itself. And then sort of invite Diana to mention what we can expect from the UAE in terms of its post-COVID response, particularly when it comes to foreign investment into the UAE. So I think we'll just kick off with the scope of taxation where we have a foreign element, foreign ownership of a company, and then obviously a foreign settlement of a trust and potential beneficiaries of a trust, and then the exchange of information on the CRS. So Diana, if I can invite you to help us through this.
Thank you, Zach. Hello, everyone. So the UAE has always been known for a tax-free country. We've never really had tax in our lives, except for the last 2 years, since the GCC has come up with its own VAT tax. The VAT is mainly not the kind of tax that would be on income or of that sort. It is just a VAT, and in the UAE is still at 5%. So when I look at the assets that Akash has in the UAE, he has a DIFC trust, but he has a property or a company. They may be onshore. So it's not really clear here for us, but the most important thing in the UAE is to look at the onshore and offshore in order to decide how does the tax work. The VAT is onshore, mandated, obligatory, the 5%, but on the trust, there is no tax. So it's the trust is VAT free.
Right.
Now, yes. So far, this is what we can see here from the assets that Akash owns. Now, the CSR, we know, as far as the trust is concerned, there are strict rules in the DIFC on CSR, and failure to comply would lead to some penal consequences. Now, does the UAE and India have a treaty of that sort? I don't believe that the treaty is required here, because the CSR rules are applied in DIFC regardless, as long as there is an account owned by a trust in the DIFC, the CSR rules would apply.
And in the post-COVID, do we think that the UAE is likely to in any way change some of these tax-free bases going forward, or do you think that it's going to be more encouraging to foreign investment into the UAE, particularly net worth individuals?
I'm glad to say that so far we did not have any initiatives or any measures as far as tax is concerned. In our neighboring state, like the Saudi, they've put their VAT immediately at 15%, but the UAE is still keeping the 5%. And luckily, just to attract foreign investment, I think that is a very wise step.
Right. Okay, thanks very much for that. Now, the US side. So here's the current question from the US, because obviously Akash holds an account, and he also has property, land in the US. So scope of taxation of foreign ownership, exchange of financial account information, FATCA, so looking at the Indian US FATCA arrangements, and the recent US foreign landlord enforcement action and what that looks like, particularly if the US land is let out commercially. And then the US tax implications from the recent election for an Indian individual that holds assets in this way in the US. What can they expect to see, if anything, in terms of the treatment being changed? So I'd invite Ivan and John to just make some comments.
Sure. Thanks, Zach. From a U.S. perspective, have to start off always with the idea that U.S. is a bit unique worldwide taxation on U.S. persons. But in this instance, we have a non-U.S. person that's owning these assets in the U.S. So non-U.S. persons still are liable for U.S. tax. The U.S. system will break down into 3 tiers. So federal level, which is most of what we'll be talking about today, but there's also state level, and then in some instances, local or city level taxes that could be at play. We'll touch briefly on those and more substantively on the California side later in the presentation. But just keep in mind when we talk about the tax effects here, we're talking about 3 tiers, and then we'll divide it into income taxes and then transfer taxes, estate and gift taxes. So in this particular instance, you've got the account in the US. The non-US person could be liable to US tax to the extent that that account is holding US securities. What the liability is could be just a straight withholding if we're talking about simple, ordinary dividends and interest paid off of holding those securities. It could, however, be exempt if we're talking about capital gains, because the US takes the opposite position, if I understood correctly, that India takes when it comes to sourcing. It's not about where the asset is located. It's about the residence of the individual who sells the asset and realizes the gain. And so the US wants to incent investment into the US, so they relieve a capital gain liability from non-US persons. That's the general rule. When we look at the other asset in question here, the real estate, we're now dealing with the exception to that rule, though. The US has reinstituted a capital gain equivalent called FIRPTA, Foreign Investment in Real Property Tax Act. It's basically just a capital gain on US real estate that's bought and sold by non-US persons. So in this instance here, we'd have withholding tax on dividends and interest that's paid off of the account. The exception there also, portfolio interest. So bonds, most bonds, when they pay out, wouldn't have that withholding obligation. Again, another incentive to get non-US investment into the US debt, into US debt instruments. And then on the real estate, any type of rent that's charged is going to be ordinary income, US sourced. You'll have a liability. That regularly wouldn't be handled by withholding. Most US persons that are renting a home from someone don't realize that they would have a withholding obligation. They'll just pay the rent. So the recipient's going to file what's called a 1040 NR, or a 1040 non-resident return, and pay US income tax on the rent that they received on the property. Then if they sell the property, they'll owe on the capital gain, so the spread between the purchase acquisition cost of the property and then the realized sale price when they do sell it. And then overarching over all of this is a transfer tax liability. So US persons have a worldwide transfer tax liability, estate and gift tax, any asset they hold. As an example, if I hold an asset while I'm living in Singapore and I gift it to someone, or if I die holding it, I have US estate tax exposure. However, I have a very large 11.58 million lifetime exemption. So most US persons are subject to estate tax on their worldwide holdings, but will never actually pay it because they won't accumulate over 11 million in assets in their lifetime. But a non-US person, like we have in the situation here, has still a US estate tax liability only to the extent that they're holding US situs assets, but a very small exemption, only 60,000 US dollars. So anything above that, they would be subject to US estate tax. Here, the land is most likely and the building most likely worth more than $60,000. So you would have a US estate tax exposure to the extent that it's held directly. If it's not, there's a fairly straightforward and simple workaround here is to hold that land on the other US situs assets like the US stocks and securities, hold that in a minimally in a PIC, an offshore company, or maybe combine that underlying company with a trust of some sort like we have in the example above. That's a shielding technique for that exposure. When it comes to exchange of information, the US is not participating in CRS. So they have FATCA, they're getting data about US persons around the world that have financial accounts or are controlling persons of financial accounts. However, don't get lulled into a simple yes, no answer on that, because while they're not participating in CRS, there are reciprocal arrangements available to any country that wishes to enter into it with the US. And an example here in the country that I'm in right now, Singapore, recently switched from a non-reciprocal intergovernmental agreement to a reciprocal. So when that goes into effect, Singapore will now start to get data from the US as to Singaporeans who hold accounts in the US. Now, it's not one-for-one data. So the type of very onerous and rigid rules that FATCA and CRS put in offshore, those have not been implemented internally in the US. For example, trustees of US trusts do not have most of the onerous reporting obligations that fall on offshore trustees. However, as Zach highlights on the slide here, the US has started to become more aggressive in their enforcement of FIRPTA, so identifying non-US persons who own real estate and might collect revenue because of it. So we're hearing rumblings that this could have a connection effect with FATCA reciprocal agreements. The US could become the first country to start to lead the way in exchanging data around values of real estate holdings, which are currently not used in the calculation of the CRS data that is set, either from an FI perspective or a controlling person of an NFFE perspective. So just something to be careful and watch out. If somebody talks to you about the US doesn't participate in CRS, it's the last great jurisdiction for you to legitimately and correctly hide wealth, that may be true in the short term and in a very technical reading, but the devil's always in the details, and you don't want to spend a lot of time and money to structure yourself into something if the primary intention is preserving privacy, if you know that a reciprocal agreement could be signed at any moment, or there's a heightened attention being paid by the US to foreign ownership of real estate, which could result in a reporting of that value that would not otherwise be reportable under CRS in a different jurisdiction.
Yeah.
And then go ahead. Yeah.
From my understanding, is it right, and also Trio for you, that the FATCA arrangement between the US and India it's on a reciprocal basis? Is that correct?
That's right.
Right.
Yes.
So in this instance, we would have the US financial institutions would be exchanging information with the Indian tax authority on what Akash is effectively getting in the US, whether it's interest or dividend. Is that right?
That's correct. And in fact, the Indian tax authorities have also put out communication to this effect, where they are coordinating with the regulators on the kind of information disclosure that we would be making and collecting information in relation to.
Right. So John, on to the election implications for Akash holding land and investments in the US, what sort of, in brief, what do we expect? Is it going to get bad for him?
Yeah, it could. So I'll give you the downside, and then I'll kind of maybe make people feel a little bit better with a brief discussion, as I mentioned at the start, with the political practicalities. So from the worst case scenario, or the downside here, the ordinary income tax rates that will be in effect on rental income that's being charged on the property, those could very well rise under the new presidency. We could also look at loss of basis step up. So when we talk about normal foreign grantor trust planning, holding property for next generations and them taking it at a stepped up basis, that could be eliminated. And so you wouldn't have the next generation. You would have an estate tax exposure of some sort, a wealth tax equivalent, but no step up in basis. So then the next generation would also face that capital gains tax, not if they're exempt. Okay, but again, we've got the FERPTA that would put it back in with real estate, and then with a lot of this planning, sometimes the people will send the second or third generation family members to the U.S. and they become U.S. persons, which expands the liability. Now, having spoken about that increase in the potential exposure on both an income and a transfer or estate tax side, the practicality right now, as the lay of the land sits, is that the Republicans will maintain control of the Senate. It appears that it's 50 to 48 at this point, with 2 special elections that will come at the beginning of January in the state of Georgia. If the Democrats were to win both of those seats, that would be a 50-50 tie in the Senate. And a tie in the Senate is broken by the vice president. In this case, that is Vice President-elect Kamala Harris. So the Democrats would have control under that scenario. However, the state of Georgia is a rather conservative state, and both of the individuals who were in the runoffs from the Republican side, the Republicans garnered a much larger amount of the vote than the Democrats. The reason it went to a runoff is neither candidate got the required 50% plus one to not have a runoff. So they were below 50, but they were the overwhelming leader in the race. So it's not likely that Senate control will flip, meaning it will be tougher for any of these changes to actually go into effect. So we would expect that the status quo would maintain for at least 2 years. But if the last year or 2 years has taught us anything, making predictions can be utterly folly. So we just have to wait and see how those runoff elections occur.
Okay, thanks very much, John. So just going to the UK side, and I'll go through this quickly so we can get on to the sort of meat of the cross-jurisdictional aspects. From the foreign sort of scope of taxation from the UK, the CRS, as well as post-COVID. I think it's pretty much like the US and the UK, you'll have source related income. Obviously, the India and the UK have a double tax treaty in effect. For instance, Akash here would be entitled to his personal allowance in the UK. Any source income, so if it's dividends, there'd be no tax deducted at source, but if it's interest income, there'd be some deduction, although the treaty will have an effect on how much can be deducted. And on the UK land, if it's not being held through a company, and of course, Akash is a citizen, resident, and domiciliary of India, so we have no UK complications in that regard. If it is being let out, it will be subject to the non-resident landlord scheme. And in that instance, Akash can try and opt to have rental payments paid gross so that he can actually pay the tax later on. Otherwise, the letting agent will be the person that will likely do it, or default of which any tenants. But in this case, the scope of taxation is very much on a source basis. There's no other connectivity other than the assets in the UK. From a CRS perspective, UK and India are fully live on CRS, and there is an exchange each year. That's been by virtue of the multilateral competent authority agreement agreed between the 2 jurisdictions. And they were both effectively quite early on in terms of the adoption of the CRS. So this has been going on for a number of years now. Post-COVID tax administration response, nothing really to report yet on this. There's obviously been some tweaking on sort of non-residents owning properties in the UK and some SDLT or stamp duty hikes for that, but nothing targeted at the moment. Perhaps we might have some of this discussion that's happening at the moment with wealth taxes, and that may affect the UK property land, but it's too early on to see if the high net worth segment are going to be specifically targeted as part of a COVID recovery plan for the UK. So fairly similar to the US, although not necessarily as aggressive. Okay, now moving to more the private client aspect rather than taxation, domestic community property, and looking at it from an Indian perspective. So this is looking at the marriage between Sapna and Akash. And the simple question is this: does India actually have community property as part of its family law, Shreya?
We don't generally have a concept of community property, although I should caveat that our personal laws are religion specific and sometimes geography specific. So for example, in the state of Goa, which was under the Portuguese rule even after independence for a while, there are provisions that say that if your parents are Portuguese parents, or if you're an individual who resides in Goa and who is domiciled in Goa, then community property could potentially apply. And in that situation, what the couple needs to do is before they get married, they would go to the registrar of special notaries and register their individually held property as their separate property. And they would probably enter into a prenuptial agreement as well. But for all other individuals, generally there shouldn't be a concept of community under Indian succession law.
Right, so each party to the marriage separately owns their property and there's no automatic pooling. Right, okay. From a domestic divorce perspective, again, staying with India, and here's the questions: on the basis on which the Indian court will actually exercise jurisdiction to grant a divorce? Is it on the basis that the couple were resident in India, domiciled, citizens of India? What's the basis? Whether the court may exercise discretion to divide matrimonial property, is there a concept of that? Whether prenuptial and postnuptial arrangements are enforceable in India. And then finally, whether an Indian court would seek to make orders that have extraterritorial effect, because obviously Akash holds assets around the world, so that would be within the mix of potential matrimonial property. So the basis on which an Indian court would exercise jurisdiction, you know.
Sure. Thanks, Zach. So before I start, Zach, I should caveat again that Indian personal laws are religion specific. So just to give you an idea, there are several legislations under which couples could get married in India. If both the individuals who are getting married are Hindus, then they could potentially register under the Hindu Marriage Act. If it is a couple from different religions, then we have something called the Special Marriage Act. And if it is, for instance, Indian origin individuals who live outside India, then we have a Foreign Marriage Act that could potentially apply. So you need to look at what is the relevant legislation under which the individuals are married to figure out how the divorce procedure would work. Just to give you a sense, under the Hindu Marriage Act and the Special Marriage Act, some of the situations where an Indian court could exercise jurisdiction are if the marriage was solemnized in India, or if the respondent is resident in India at the time that the petition is presented, or if the parties to the marriage last resided together in India. So these are some situations where an Indian court would exercise jurisdiction under the Hindu marriage or special marriage legislations. And similarly, under the Foreign Marriage Act, an Indian court may grant a divorce if the parties to the marriage are domiciled in India at the time that the petition is presented, or if the petitioner, being the wife, was domiciled in India just before marriage and resided in India for a period of at least 3 years just before the petition is presented. So this is primarily to deal with a situation where an Indian resident woman gets married and then moves abroad and then registered under the Foreign Marriage Act, but then the marriage breaks down and she comes back to India. So it would depend, but broadly speaking, if there's residency in India or domicile in India, there's a fairly good possibility that an Indian court would exercise jurisdiction. And this would apply to division of matrimonial property as well. Although since we discussed that there isn't a concept of community, it would basically be the individually held property that they would look to divide. On prenuptial and postnuptial agreements, again, it would depend on the personal law that is applicable. So for example, Hindu marriages are considered sacraments. They're not considered contractual. So you don't consent to a Hindu marriage in the way in which you would consent to a Muslim marriage, for instance. So Muslim marriage under Sharia law is not valid unless both parties say that they accept the marriage. And so the nature of these two under the respective personal laws is essentially very different. And that sort of motivates how a prenuptial or a postnuptial agreement would be treated as well. So although we don't have specific laws dealing with this, we do have a general provision in our Contract Act that says that agreements in restraint of marriage are not valid.
Right.
And courts have relied on this provision to interpret how a prenuptial or a postnuptial agreement should be considered. And in some situations, they have been held to be valid so long as they're not against public policy. So long as the court doesn't assume that they're motivating the couple to break up the marriage, they can be considered to be held valid. But it would be a very fact-specific decision, and it would also be motivated by the respective personal law and how it approaches the concept of marriage. Extraterritorial orders. So this is a slightly more elaborate question. The short point is, yes, it would be possible for an Indian court to pass an order that applies to foreign assets, but it would depend on a number of things. So, for example, under our conflict of laws principles, we have the concepts of effectiveness and submission. And what these mean is that the effectiveness means that a court can only pronounce a judgment in a case where it can execute the decree within its own territory.
Right.
Whereas submission means an acceptance of the authority of a court to pass judgment. So before an Indian court passes judgment in relation to foreign assets, it would undertake this analysis.
Right.
But in most situations, what would happen is that the the nexus principles that we discussed in the context of when a court would take up a divorce case,
Yes.
that nexus would automatically give them the ability to pass this judgment.
Right.
So what they would then do is, as long as the party is domiciled in India, they would pass the judgment in relation to foreign assets. But then that judgment would need to be enforced in the relevant foreign country based on whether it recognizes India's ability to grant that divorce or not.
Right.
And the Supreme Court has also provided some guidelines in respect of how this could possibly be done. So, for example, if there's a divorce proceeding that's filed in India, then the parties need to make a disclosure of foreign assets in that proceeding.
Okay, very good, very good. So I think from just following on from that, Shira, we'll look at how this can be, how this will affect, in the case of Akash, his assets overseas. So would a UAE court recognize and enforce an order issued by an Indian divorce court? And can a DIFC trust be varied or terminated by an order issued by an Indian divorce court? So Diana, from this instance, we're looking at obviously the marriage breakdown between Sapna and Akash, and we have an order emanating from an Indian court, which is effectively proposing to split possibly the shares of the company and potentially bringing the trust to an end. Is this likely to be enforceable or recognized in the UAE, and particularly in the DIFC?
Well, let me start by saying that if I was instructed to enforce a foreign judgment, whatever it may be, including a divorce judgment from India, I would say the UAE Civil Procedures Law has quite strict provisions that may be difficult to meet by many of those divorce court orders, unless and save for if there was a treaty between the UAE courts and another court for the enforcement of judgments. Now, we have very little treaties.
Right.
So most of these court judgments that are for divorce are hardly enforced, despite the fact that we had a great amendment to the Civil Procedures Law 2 years ago, but it did not really break the public order challenge that we would always have to, in a way, start on that nexus in order to enforce a judgment. Now, if we're talking about the DIFC trust
Yes.
particularly. Now, let me say that the DIFC, if it's not a trust, like let's say the business is part of a DIFC and the foreign court judgment is coming from a court that has had some agreement with the DIFC. The DIFC courts are much more lenient on enforcing judgments than the onshore courts, that's for sure. However, for the specific issue of a trust, it is quite, as I explained to you earlier, Zach, that although there are the firewalls in the trust law of DIFC that would not enable much of a foreign court judgment to come through and change the rights of the beneficiaries. And however, it seems that it's very clear that there is some kind of let's call it like, you know, the trust law would allow what is a community property that would come into the courts of DIFC challenging a trust to be accepted.
Right.
On the basis that originally the ownership of this trust was not mainly for the settlor in this case. So the DIFC law, trust law would allow it.
Right, but in the case of a court order that wasn't community linked, it was just a sort of discretionary order to vary the terms of the trust under an Indian proceeding, that the firewall protections under the DIFC trust station, they would prevail, wouldn't they? Right. Okay.
Exactly.
All right. Okay. Thanks very much, Diana. And turning now to the US side, will the US court recognize and enforce a similar order emanating from an Indian divorce court? And I'll do the same for them. So from your side, John and Ivan, what say you?
Thanks, Zach. So the short answer is yes. It's going to vary, though, on a state-by-state basis, because unlike taxation, we're not looking at a federal tier from an enforcement perspective. So divorce is regulated on a state-by-state basis. It'll depend on the state law, their definition of residency, and their approach to certain community property rules. As we'll see in later slides, and we'll save the more full discussion of this for the US source or the US resident discussion we'll have in the second example, but you'll see that California, that Ivan is admitted in and will speak about, is a little more aggressive in this regard than other states like my home state of Kansas in the center of the US. But in general, the answer here is yes, the court's going to recognize it. And in a situation like this with little to no connection, assuming that one of the owners is not living in that property, they're using it as investment purposes, probably very little connection from a US law perspective, they would just enforce the order and deal with it the way that the other country had said.
Right. Okay, so a similar one for me for the UK. I think the UK is a bit different. So UK will generally, even at common law, there's a few statutes that deal with sort of enforcement recognition. They would tend to only look at an order that has a sort of monetary side to it. So they would only look at liquidated damages as a way of enforcing, where the Indian court order was effectively trying to sever property or transfer property. I think they would find it quite difficult to enforce that in a UK court on a reciprocal basis. Okay, so looking at domestic succession, which is the last part of the domestic slides. So here we have the situation where Akash actually passes away, survived by Sapna and Anika, the daughter. And the question that we'll ask is, the basis in which Indian succession law would apply, was it nationality, residency, domicile, situs? How does Indian succession law apply? And does Indian succession law contain forced heirship rights? So this is quite a critical question. Does it permit full testamentary freedom, which is the reverse of forced heirship? And then does an Indian succession law permit what we call financial dependent claims? So people that were dependent on the deceased, are they able to challenge what was in the will, or are they able to make claims for financial maintenance post-death? So Shreya, if you can take us through from the Indian succession aspects.
Sure. So the general principle on Indian succession is that movables are bequeathed as per the domicile of the individual, whereas immovables bequeath based on the situs. So what that means is, if it's a non-Indian domiciled person who owns real estate in India, or if it's an Indian domicile person who owns assets wherever that person may own these assets. In both those situations, Indian personal laws would apply. Indian succession law may contain forced heirship rights. It would depend on the religion of the person. So, for example, if the person is a Muslim, then forced heirship rights would apply under Sharia law applicable to Muslims. But for most other religions, we don't have a concept of forced heirship. I should caveat that for Hindus, there is a concept called the Hindu undivided family, which is it's a form of collective ownership of property, which could impose restrictions on free bequeathal of property, similar to what you may find in the context of forced heirship. But it's not an apple to apple concept, but it would need to be evaluated. So aside from these situations, Indians would generally have full testamentary freedom. And there wouldn't be restrictions in terms of having to leave the property to relatives, for instance. And there would also be restrictions on financial dependence from being able to make claims, assuming that the will has been made validly if there is a will, or assuming that there's an interstate succession, in which case we have legislated rules which apply.
Right, okay. So from the UAE perspective, the question here is obviously Akash has passed away, and he held prior to death shares in a UAE company, and he had also settled a trust. So the question is, would an Indian will be recognized and enforced in the UAE? So this is a will that was executed in India, so it's not a UAE will as such. Which succession law will apply to the company shares if Akash dies without a valid will? So he didn't have a will at all. And then can the validity of the DIFC trust be challenged on the basis of foreign succession law rights?
Well, before last Saturday, my answer to this question would have been an Indian will would never have been valid in the UAE regarding an onshore or an offshore asset in succession. So, but since Saturday and the new laws that have been introduced in the UAE regarding many issues, and one of them is succession planning, a will that is valid, entered, executed, and valid in the country or whatever country the deceased has had before death would be valid in the UAE and would be executed in the UAE upon the law of the country where the will was issued. So this is a new thing for us. And now I can say easily a will save the day for every expat that is living in the UAE with assets in the UAE. Now there is a bit in the same media release on these laws that said, save for the UAE assets. That leaves us also in a shaky situation. But I would say probably that the better way would have been to have a DIFC will to cover the assets, including whatever would have been in India. So it would have to be a unified will in a way of two jurisdictions. However, now the will is not there, and Akash has passed away without a will. What would happen as far as a DIFC trust, and would it be challenged on a foreign succession law? Again, the default situation would be not, because of the firewalls that are already in the trust law. However, and again, bearing in mind that the Indian laws, as far as divorce are concerned, not necessarily divorce here, sorry, Shreya, the succession planning, I'm not really sure how would they have been as far as religious issues of also in India. So the idea is that foreign judgment in India, if in any way is for a Muslim, that would actually be implemented immediately in the UAE onshore. That would have made it much easier. And if it's not a Muslim, that we would have again to go with the Sharia route. So we're not really sure how would it be after Saturday, except for the DIFC trust. I would say that we would still go with, if there is a community property with the wife, that would prevail here.
Right. So, Diane, if I understand you, when we look at Akash's shares of the company, he died without a will. And so there's nothing in the UAE under the new law to attach to. Are we saying at the moment that it's uncertain how that situation will be played out, or would it be you apply the old rules of just, well, you apply Sharia law to it, regardless of his religion, or how does that work?
We don't really know, but they say the law of the deceased. So it may be the Indian laws,
right,
but we don't really know how it's going to be as far as the Sharia, which is again a public policy, would be the stand then.
Right, okay. All right, so just moving on, there's no tax implications, so we don't need to worry. In terms of the US side, so would an Indian will be recognized in the US? Which succession law would apply in the US if Akash dies without a valid will? And which succession law will apply to US land if Akash dies without a valid will, India or US, and then the local tax implications? So, John, if you can run us through that quickly.
Yeah, just as we touched on with the divorce concept, remembering on succession, the important point is that there is no federal element of that. That's going to be regulated on a state-by-state basis. The first analysis is exactly what your questions map to. Is this intestate or testate succession? It's why we always say if you're going to hold U.S. assets, at a minimum, you want to have one will for common law jurisdictions and one will for civil law jurisdictions. Maybe you go with one will for the particular property in the US, depending upon the other common law jurisdictions that are involved. So would a will be recognized in the US? But potentially, you want to be careful about some of the little nuances of how things are taxed versus wrapped. So we can use testamentary trusts and some other shielding actions before time in a planning effort to shield against US estate tax exposure, local transfer tax exposures when it is the offshore company shares that are being exchanged when the person dies rather than the property in the US, movable or immovable property. So yeah, keep in mind local tax complications, state by state. The most onerous is California, and we'll touch on some of those particular details in the next section about US specific planning.
Okay. And then looking from the UK, I'll cut through this fairly quickly. With Indian will be recognized if it's properly executed under Indian law, domicile of the individual, then that'll be fine. So if it's valid in India, then the UK will recognize that. Would succession law apply to Akash's, which succession law will apply to UK investments if Akash dies without a valid will? Well, in the UK, what will happen is it will default to the domicile. So it'll be Indian law that will cover the succession to his movable assets in the UK. And then on the land, it will be UK law that covers that. So UK intestacy rules, and then the Indian intestacy rules will apply to the movables. And then the tax implications, this is going to be an inheritance tax issue, potentially, depending on the values of the assets and where they go. There's no double tax treaty on the inheritance tax side between the UK and India. India doesn't have an inheritance tax law yet. So there's no issue there. In terms of the exposure, though, it will, as I say, all be down to where the assets go. Does it go to SUPNA? Or alternatively, is the assets going to go elsewhere under the intestacy rules, particularly? So that will drive the inheritance tax treatment, but there would be, depending on the values, an exposure to UK inheritance tax in this instance. Okay, so sorry, case number 2. So looking from the foreign perspective, and I'll just canter through this quickly. So here we're looking at Vishal, married to Jenny, and has a son, Aaron, in the US. Now, key thing to understand about Vishal and the family is that they're US resident, but they're, in the case of Vishal, he's an Indian citizen, so it's an NRI. So resident in the US, in California, holding the array of assets that we see there, land as well as accounts. Now, in this case, Vishal had previously set up a UAE will, and also has a UAE trust, rather, as well as has an interest in an Indian trust, has accounts and land in India, and then the usual accounts in the UK with UK land. Key point to note here is Vishal is a non-resident Indian and is resident in California, in the US, but retains his Indian citizenship. We don't know the domicile of Vishal, so that's left hanging as an item. So for community property, and this is looking at it from a Californian perspective. So whether community property rights apply in California, whether community property rights includes pre-acquired and inherited property, and the position of pre and post-nuptial arrangements. So I think I'd invite Ivan to run us through this from the California perspective.
Sure. So California is one of 8 states in the US that recognizes community property. In California, community property is broadly defined as any property acquired during marriage by either party's labor. I'll say that again because the definition is important. Any property acquired during marriage by either party's labor. So which the definition itself should answer the second question, whether community property includes pre-acquired or inherited property. And the answer is no, because property acquired by gift, property acquired by inheritance is not acquired by labor. So will not, therefore not form part of the communal estate. Whether a prenup or a postnup agreement is valid in California, is particularly these are foreign law prenups and postnups. California, like a typical lawyerly answer, maybe. California might recognize the validity of pre and postnups of other jurisdictions. The issue would be California would apply its own standard of validity on the pre and postnup. To summarize things, really California looks at whether or not the disadvantaged spouse had counsel when he or she signed the pre or postnup. If the spouse had counsel when he or she signed the pre or postnup, then chances are California will recognize the pre or postnup.
Okay.
I'll just add real briefly there, Zach, sorry, just to close that off though. The US has an emphasis on avoiding custody or duty elements. So don't try to divvy up the kids or it's my responsibility to do this task or that task. That's typically a no-go in general in the US, even beyond California. And then from a timing perspective, and this connects to having adequate representation that Ivan mentioned, at least 6 weeks out of the marriage. Do not try to rush the person the week before the marriage. Hey, sign these documents. That's got very little chance of being upheld in the US from a US perspective. Thanks.
All right, thanks very much, John. Okay, thanks, Ivan. Okay, so from a divorce perspective, here we have the couple, Vishal and Jenny, divorcing in California, and basis on which California court would exercise divorce jurisdiction, and would a California court seek to redistribute property, including community property, and how would they enforce a pre and post-nuptial agreement if that was actually agreed in California? So again, Ivan, I'd invite you just to run us through briefly these factors.
Sure. So California's basis on which to exercise divorce jurisdiction is more so of a factor test. There's a few factors. Number one is first in time, whether or not this is the first court in which the couple tries to proceed with a divorce. The second one is primary residence, whether or not the couple's primary residence is based in California or another state. And the third one is location of assets. So suppose one spouse tries to get divorced in California, the other party could argue California courts to that the California court is an improper venue and thereby try to change the venue. And the California court would then look at all right, are we the first in time? Is this the primary residence in California? And are the assets in California?
And
whether or not, sorry.
Just on the community point, would they actually, when exercising the divorce court powers, could they try and redistribute even community property?
They would. They definitely would. So I think that the tricky thing is community property is already owned 50-50. So if any property that you obtain that's community property, even if it's titled to one person, for example, with let's say a primary residence in California, let's say it's titled to the wife's name, but because it's community property, upon a divorce proceeding, the court would say, look, that's 50% the husband's, 50% the spouse, the wife's, in which case California court a lot of times will either force one party to buy the other 50% or force the sale of the property and then split the proceeds 50-50.
Okay. And then the nuptial arrangements, I guess it's all down to what you said before.
Mm-hmm. Yeah, validity.
But if they are valid, then the court should follow what the nuptial agreement said. Is that right?
Absolutely. Right. That's right.
Okay, I think it's a fairly simple question from Diana. This is the whole thing around the DIFC trust. From Ivan, from your perspective, California can do extraterritorial orders under a divorce proceeding. They're capable of doing that?
Yeah.
Yeah. Okay, so we could have a situation where a DIFC trust is being challenged by a court order from the US. And I think, Diana, it's pretty much as we mentioned before.
Exactly.
Yeah,
It is the community property that would prevail here. And
right, but
yes,
the order that wouldn't, yeah, because the trust protections are so strong on DIFC trusts that they wouldn't recognize a foreign court order try to exercise a discretion here.
Unless, yes, unless that is the situation. Now, I have to say that onshore, now, I think prenups will be the happening thing because of the fact that we are gonna eventually go with the law of the marriage. We will have the prenups being, you know, the norm, which has never been before. So we're just waiting for the new thing of having prenups done, yes, extensively.
I think you're going to be very busy, Diana.
It seems so.
Okay, so Shreya, from your perspective, here we have a court order emanating from the US, from a Californian court. And the question that we're going to ask is, will an Indian court recognize and enforce the terms of that, given the array of assets that are held, an interest in a trust, an account in India, land in India? If a Californian court tried to sort of change the legal ownership of any of this, how would it be received by an Indian court?
So it could be considered conclusive, Zach, although there are some exceptions where this may not be the case. One is where the jurisdiction of the foreign court is challenged, or where the divorce decree is considered to have been given in a manner that's opposed to natural justice, or in a manner that's fraudulent, for instance, or if it results in a breach of any law that the Indian court thinks should be applicable in India. So one common situation that that you may want to keep in mind is that a lot of non-resident Indians, even when they are permanently resident outside India, they frequently come back to India to get married. And so they may actually be registered under an Indian legislation, like the Hindu Marriage Act or Foreign Marriage Act, for instance. And in that case, you need to evaluate whether the condition for divorce under Indian law is different from the condition applicable under the relevant foreign law. So, for example, bigamous marriages under Hindu law are voidable at the option of the wife in India. They're not considered to be void immediately. So if there's a conflict in the foreign jurisdiction with a concept like that, for instance, then there could be a situation where the court would say that the two laws applicable are essentially in conflict, and therefore we will not enforce this foreign judgment. But barring situations like that, it should generally be possible for foreign divorce decrees to be enforced in India.
Right, okay. So far as the UK side, it comes back to what I said earlier, where we have an order trying to sever property, that generally won't be recognized. But if it's liquidated damages or a money amount, then the reciprocal should kick in. But in this instance, if they're trying to split UK property, then this won't be something that the UK courts would generally entertain. The final section on this. So succession. So here we have Vishal passing away whilst resident in California and retaining his Indian citizenship. Basis of application of California succession law, how does it actually kick in? Is it citizenship, residence, domicile, situs? How does it work? Is there forced heir rights under California law? Which succession law will apply to land located in California if Vishal dies without a valid will? So without any valid will, how will it apply to the land in California? And then likewise, when it comes to which of the succession law will apply where it shares an investments located in California, but Vishal dies without a valid will, and then the tax implications. So I'd probably invite Ivan to run us through briefly how this will play out.
Sure. So if you pass away domiciled in California without a will, then California's intestacy statute will apply. Right. Typically, that just means your community property goes to your spouse, and your separate property may go to your spouse and your children. If you don't have any spouse and children, then it goes to your parents. If you don't have any parents, then it goes to your siblings.
Okay. Sorry, go ahead. Sorry.
And if you're not otherwise domiciled in California and you die without a will, then California's intestacy statutes will only apply to California situated assets, so meaning California real estate. California does not have forced air rights. California respects the free disposition of assets. Having said that, because there's community property, you have to be mindful that not all assets under your name that's titled to you is for you to dispose. So for example, if the house that's titled under one spouse's name is in fact community property, that spouse can't actually dispose of the entirety of the house on his or her will. You can only do half of the house.
Right. Okay. And then the tax implications, as we mentioned before.
Sure. So what's important to keep in mind is, so California does not have an inheritance tax or estate tax. It used to have an inheritance tax, no longer. So if you pass away in California, there's no state estate tax. Having said that, if you pass away in other states, for example, New York, you will be hit with a state tax. Another tax implication will be property tax, just in particular with the California real estate. California state counties impose generally about a 1% property tax annually on the purchase price of the property. In California, receiving a property by bequest, by inheritance, does not sort of re-trigger the property tax assessment. So the property tax is going to be based on the purchase price rather than the fair market value upon receipt. But that's just California. And it's absolutely important to keep in mind that in other states it will vary. The base is the property tax and the base is the estate tax.
Right.
And in most states, you can avoid both of these problems by owning it through a structure, by owning real estate through a non-US company.
Okay, and just to think very quickly on the DIFC, although this is an interesting one, Diana, because here we're saying, will the DIFC trust law provide protection against a California community property claim? So this is not divorce or anything like that. This is looking at, obviously California confers community property within the relationship between what was Jenny and Vishal. In this case, we're looking at Jenny effectively making a claim against the trust for community property. How will that work if it's a DIFC trust? Will that be an acceptable claim? Sorry, Diana, you've got mute on still. Diana, yeah.
Yeah, this is the the confusing thing about speaking when you are on mute.
Yeah.
Well, with the DIFC trust law, we'll have to look at Article 14, which is titled Limitations in Foreign Law. And if we look at Article 14, it actually has all the non-voidables of a trust in DIFC, keeping it protected. However, when we look at sub-article 3, that would say, notwithstanding this article, this is when the court determines that at the time when the property was transferred to a trust, a settlor was insolvent or intended to defraud any creditor. And this is where the creditor here in this instance is the wife, according to the order that she would get from California. She would become, according to her claim, part of this trust.
Right. Okay. And then I guess briefly, just from the India perspective, which succession law would apply to land located in India if Vishal dies with a valid will? Is that going to be India or US? And then which succession law will apply to shares and investments located in India if Vishal dies without a will? So this is, so Shreya, we're looking at the usual scenario here where we have a will that's been executed in let's say the US, and then one where Vishal passes away without having any wills at all. How will the estate in India pass?
So thanks, Zach. So the assumption here is that Vishal is domiciled in the US. So starting with that, immovable property would be governed by the law applicable to the situs. So if immovable property is in India, then Indian succession law would apply. And this would apply irrespective of whether there's a will or whether there's interstate succession. So for example, if there's forced heirship applicable under the relevant personal law, then the immovable property would be subject to that. But shares and investments, since Vishal is a non-domiciled individual under the current example, should not be covered by Indian law because India would follow the approach that the law of domicile should govern it.
Right. And then the tax implications, there's not going to be anything at the moment because we don't have. Right. Correct. Okay. All right. So finally, I think on the UK side of this, which succession law will apply to land located in the UK, official dies without a valid will? Well, in this case, if we're looking from a California perspective, it's going to be land located in the UK. From a US perspective, it will be UK law that will cover that if there's no valid will, because it's going to be a situs-driven aspect with succession law. Will apply to shares and investment located in the UK, official dies without a valid will. That will be US, so it will be US intestacy laws that will apply. And would Jenny's California community property rights be recognized in the UK? Yes, the UK would take cognizance of the matrimonial domicile, and if that provides for community property, then the UK would likewise take that into consideration. From a tax perspective, Vishal will have made a transfer. The UK and the US do have a double tax treaty on IHT, but it wouldn't be applicable here because California doesn't have that concept at the moment. And so it'll be down to the whole issue of the values and where the property is going to determine whether or not there's an inheritance tax exposure from the UK perspective. Okay, I think that's pretty much it from us on terms of the main sort of run through. We've got a number of sort of questions that have come up in the chat, and if we're happy to run through, I'd invite us to look at this. Some of them have obviously been answered already, but I think. Sorry, go ahead, John.
Yeah, Zach, I'll put my hand up first. I answered one of the questions in the chat, but I think it is very important for everyone to grasp this concept that was asked because it wasn't addressed in the examples. In our examples, we talked about somebody who is India resident, a tax resident and living in India, holding US property. And we talked about somebody who is resident in the US, living in the US, holding US property and outside property. The question came up though, what about a US person who is registered and resident in India with their offshore holdings? And I just want to reiterate to everybody, the worldwide tax system is for all three types of US persons. That is a citizen like myself, a green card holder, because a green card, the technical name for that is lawful permanent resident. So worldwide taxation for them. And then also for anyone who meets the substantial presence test, which for a given year can be as little as 31 days. It's a 3-year rolling average. So don't get stuck on you have to physically be in the US for half the year. If you spend 2 years in the US and then stay for the first month or so and then go back, you might still be US tax resident for the entirety of that year that you went somewhere else. And that's worldwide taxation. So not limited to what you're holding within the country you're living in or what you have in the US. It's anything you have anywhere in the world. So that's a very important concept. If you have clients or friends or colleagues who are any of those three, citizen, green card holder, or spend a substantial time in the US, they need to talk to a professional and get good advice about what their exposure is. And there are programs to get those cleaned up if they've overlooked something.
Right. We have one which may be relevant, which is the NRI living in Dubai has New York properties. What happens when they pass on? Will it need a US will or an India will? So from New York, so UK, US situs property, New York. What's the best advice for this non-resident Indian?
Well, I believe, sorry, am I on? Yes, a Dubai will do here. A Dubai will cover properties in Dubai, and it can cover properties, which is a DIFC will mainly, because the DIFC is a common law jurisdiction. So the actual will would be able to cover and be able to be used by probate courts in New York and in India.
I think we did just one broad one, which is effectively, I think, looking at the difference between a California and a UK court for divorce purposes to see which one, if you were gaming the system, which would be the best one to get divorced in. So
the answer's Florida.
Okay, so there we go. Question.
They're both bad. New York and California are amongst the most onerous from a divorce perspective. So neither one of those, I would say, are jurisdictions that people seek out if they are wanting a pre-agreed arrangement to be respected or an orderly, timely transition. Now, if you're somebody wanting to challenge, that's exactly where you want to run to.
Right. Okay. Okay. All right. I think all the other questions have been already answered during the rather lengthy webinar. But I think that's pretty much it. Okay, so it just leaves me to thank everybody that helped and participated with this. So thank you very much, Shira, for coming on and helping, and thank you, Diana.
Thank you, Zach. Thanks,
John and Ivan, thanks very much. And for everybody that viewed it, a little bit longer than usual, so thanks for your patience, but thanks very much, and I think that will close it for today. Thank you.
Thanks, everyone.
Thanks,
Thank you, Zach.
everyone. Bye.
Bye.